Hello there, and welcome to lesson 5, which is trying to bring together our concepts of neutrality and independence by asking how neutral and independent are the judiciary in the UK. Okay, so going back to our revision checklist, hopefully these words are now starting to make sense, and what we need to know is hopefully starting to make a bit more sense. So, the first activity is relatively straightforward. It's using a little bit of common sense. There's stuff in the textbook on this, but it's not actually that well explained. I think it's just relying a bit on common sense. So we're debating about the ability of the Supreme Court to be really that independent and neutral. So on the left-hand side, there are arguments to say that it has been neutral. For instance, judges cannot be removed by ministers as a result of their decisions. They have a security of tenure. So what I might want to write in here is an explanation of why that gives them the security of tenure, gives them the ability to be independent and neutral. I may write in here something along the lines of it allows them to make sometimes quite controversial decisions that upset the executive. For instance, the 2016 Miller versus the Secretary of State for the EU case. In some countries, those judges in the Supreme Court could have been sacked if they'd given such a controversial and anti-executive decision. But because they have the security of tenure in the Supreme Court, that is not going to happen. And that goes down to the High Court as well, and even the Court of Appeal. So, as a flip side of that, ministers do have some influence over the final appointments of the most senior judges. So the Judicial Appointments Commission has been influenced. And actually, maybe you might want to write here that indirectly certain judges may be favoured because of their particular leanings, political leanings, or otherwise. There's certainly been some news and some noise since the election of Boris Johnson as Prime Minister with a majority in Parliament that there would be attempts to try and clip the wings or limit the power of the Supreme Court because of its judgment in 2019 against Johnson's proroguing of Parliament. Okay, so try and get through these. If you don't fill it all out, do not worry. This is not the most important page in the note taker. I actually want to run straight forward to a few more interesting things and a bit more meaty subjects. This idea of comparative politics we've talked about before, comparing politics from one country to another. And many of you would have been familiar with the Citizenship Amendment Act, CAA. You may not have heard of it like that, but this new law that has been passed in India basically removing the citizenship of millions, hundreds of millions of Muslim Indian subjects. This is part of a politics led by, or political ideology led by Narendra Singh Modi. Narendra Modi. Modi being the president of India, who has an ideology of what we refer to as Hindu nationalism, seeing Hinduism as the natural religion of India, and therefore other religions as subservient to its goals and certainly unequal to it. Now, this has actually borne itself out in the CAA, which has explicitly said that certain religious groups, particularly Muslims, are of a less value and less status politically in that country than Hindu nationals. These are people that have lived here for Muslim people who've lived in the country all their life, family have lived there all their life, and as Indian as anyone, but are having their citizenship downgraded. Now, the Supreme Court in India has a Supreme Court, made a judgment on this and were found to have, you would expect this kind of removal of citizenship from people to be illegal under the Constitution. Well, the Supreme Court basically found that it wasn't. They asked Modi to review it, to reflect on it, but certainly there was not enough, from some people's opinion anyway, enough neutrality and independence from the Supreme Court to challenge what was and what is undoubtedly a law that attacks the principle of equality under the law, or sometimes, as we call it, the rule of law. So this is one example, and certainly we could compare the UK to this. Another example is the US Supreme Court, as we've talked about before, which is certainly not independent of politics and is being brought into politics quite regularly. For instance, most recently with the appointment by Donald Trump of Brett Kavanaugh, a key Trump supporter, a controversial appointment for his record of sexual assault and of inappropriate behaviour, but also because the balance on the Supreme Court has always been a political football, whether there's 5-4 for liberal Supreme Court justices or 5-4 for conservatives. It has meant that the politics of the country, we know because the Constitution cannot change, the politics of the country, or it can change, but it requires a hell of a lot of political will that normally isn't there, that a lot of the politics of the country focuses on the interpretation of pre-written laws, and that is done by the Supreme Court. So because the Congress, presidents can't just change the Constitution like we can in this country, with an act of Parliament, it needs a certain amount of Congress to vote for it, as well as it needs a certain amount of Congress to vote for it, and we know that that's not very possible in the US with the kind of partisan politics they have between the Democrats and the Republicans. Therefore, we normally see that most big changes in US constitutional arrangements happen in the Supreme Court, and they happen through the interpretation of laws. So Supreme Court justices interpret those laws. They are almost in some sense politicians, although they wouldn't define themselves as that. They have such a political role in the US. Okay, so here, this is what you may want to have put for this table in your note taker, but I want to skip forward now to the big decision last year, one of the biggest decisions in the history of the UK Supreme Court. Remember, it's only been in existence since 2009, although it was passed by the 2005 Constitutional Reform Act. We only got it in 2009. This is one of the biggest, and potentially will be one of the biggest for years to come. The situation, as you may well be familiar with, you guys were just starting your politics course, so you were getting into it. I didn't want to overload you with it, but there was this huge decision at the beginning of September, well, not beginning of September, towards the end of last year, let's just say. And again, we've got Regina Miller, she gets involved, and also someone called Joanna Cherry, who was an SNP member of Parliament, but also, or maybe member of Scottish Parliament, but also, crucially, another citizen who took this particular case. It's got a slightly different name because actually the case was taken both in the in the English Supreme Court and in the Scottish courts, which, for very interesting historical reasons, which I'm not going to bore you with, Scotland has its own legal system and always has had. So it brought together in the Supreme Court as one case. That's why it's got a long name. You don't need to know that. But what you do need to know about this case was another case, not just another case involving Regina Miller, but another case where the executive and the legislature come to a head. Yeah, where the question of who has the power to do something, is it Parliament, is it the executive, can prerogative powers be enacted here or not? It comes to the judiciary to decide, the Supreme Court to interpret where sovereignty lies, and it's that sentence that is so important. The Supreme Court were asked to interpret, adjudicate, effectively judge, and ultimately, in this case, decide where sovereignty lay, where political sovereignty lay, who had the right to make the decision. Now, we know legal sovereignty ultimately goes to Parliament, so Parliament could pass a law to change whatever the judgment of the Supreme Court, yada, yada, yada. But the political sovereignty was at play here. And this is the question, did Boris Johnson have the right to shut down Parliament for longer than it normally would be shut down? That was the question, very simply put. And in this news article here, you see it explained very well. So you may want to read it and get into it, watch the clips. The clips are very good. But ultimately, the answer to this question was, again, that Parliament had the power. Okay, so Parliament was sovereign. The executive, Boris Johnson, was trying to claim that part of royal prerogative was that every year you shut down Parliament for a few weeks and then you reopen it. That's what he claims, and it is certainly true that that happens. It's what we call a prorogation of Parliament. Yeah, he claimed that he was just doing that as normal. However, what was notable is he was doing that proroguing of Parliament right at the time in which there was a deadline on Brexit, and he was arguably, some would say, politically making that call. He was trying to close down Parliament to make it harder for Parliament to stop him from getting a no-deal Brexit, because if he closed Parliament, Parliament wasn't open, then Brexit would have just happened, because of Article 50 being triggered, Britain would have just left the EU. And he was hoping that that would be the situation if he closed down Parliament for just a little bit longer than he needed to. Now, what Parliament said is, no, we are not idiots. You cannot shut down Parliament for longer than you normally would to reopen it, as most executives do, but slightly later, and oh, whoopsie daisy, we've left the EU. No, you are actually doing something here that is illegal. Parliament, in this case, you're trying to close down Parliament, and Parliament has a right to decide when it closes down and when it doesn't. So there was this big debate. Does Parliament have the right to close down when it does and when it doesn't? Or does the executive have the right to just do that little kind of refresh button on Parliament every year, where they close it down for a couple of weeks and then they come back with a new Parliament, basically saying, guys, we're closing down for a few weeks, everyone have a bit of a rest, we'll write out what we want to do for the next Parliament in a Queen's speech, the next session of Parliament, which is normally a year, but everyone get a bit of a rest. So the question was that, who had the right? Now, Parliament took this to the Supreme Court. And this decision, well, I say Parliament took this to the Supreme Court. It's a very important point to make that actually citizens took this to the Supreme Court, because Parliament cannot take a judicial review, only citizens can. And Regina Miller said, Boris Johnson is basically violating my right to have a Parliament, to democracy, by using executive power beyond his control. He's acting ultra-virus, as we use that term, beyond his powers. Okay, and this was the judgment. You can watch the clip here of the very famous Supreme Court Justice reading out, the chair of the Supreme Court, Lady Hale, reading out the judgment, basically saying Parliament was not able to be dissolved. The executive had acted ultra-virus. Boris Johnson had acted beyond what he should have been doing. He wasn't just closing it down to refresh it. No. He was doing something beyond what Parliament would allow it to do, and therefore he was breaching the law. He was breaking the law. Because Parliament was supposed to be sovereign, and Parliament should decide when it opens and when it closes. So Boris Johnson had broken the law. Now, he didn't go to prison for it because it was a civil law that he broke, not a criminal law. I'm sure he has broken those as well. In fact, he's admitted to breaking those, but you can Google about that if you want. He broke a civil law, and so he therefore says in this clip he will respect. Of course he will respect, because this is the judgment by the Supreme Court saying that Parliament should not have been prorogued. And so you get this weird situation where Parliament literally opens. It's been closed for a few weeks and it just opens that day. And the judgment says that basically it's never been closed, because it couldn't have ever been closed, because if it had been closed, then we'd be accepting that what Boris Johnson did was legal. So Parliament just reopens and said, oh, we've always been open. And here is the Speaker, John Bercow, who took the leadership role as Member of Parliament, but also the Speaker of the Commons, to basically come outside Parliament right after that announcement of the judgment and say, we're opening up tomorrow. And of course, many supported Parliament on that, because there was quite a lot of hostility to what Boris Johnson was trying to do over Brexit, trying to kind of bounce Britain into exiting the EU without a deal. And this article explains that really well. So I would just say worth checking out that link. And that's a lot of information. You want to kind of digest it, put it into here in the very basic terms. The very basic terms here, again, I'll just repeat, is that the Supreme Court judged that Parliament had the sovereignty, or held political sovereignty, to be able to dissolve itself or to reopen itself, and that the executive therefore did not have the legal right to prorogue Parliament, to basically close it down for a few weeks longer than it normally would be. Okay, and ultimately, therefore, the sovereignty of Parliament was, let's say, re-emphasised, was able to beat the sovereignty, or let's say the political sovereignty or prerogative powers of the executive, and that was decided by a judiciary, our Supreme Court. There are lots of other case studies here if you're interested to place them in. There's a story here of the gay cake case study. Everyone loves that one. Story here of Poundland, the gay cake, by the way, being about the rights of certain businesses and the rights of certain people in the UK. Read about it if you want to know a bit more. The Poundland case, this is a very interesting case about how the Department for Work and Pensions have been forcing people to basically work for their benefits at Poundland. They were found, the government, to have acted beyond the powers they had. They were found to have acted ultra vires. Again, a bit like Boris Johnson, but this was in 2013. It's a good case if you're interested in things like benefits and the inequalities that those systems bring in. There's a case about civil partnerships, again, one about human rights. It was under the Human Rights Act. I think that the civil partnership claim was taken and brought to the Supreme Court basically by a heterosexual couple claiming that they should have the right to have a civil partnership as well as gay couples. And also a point here, which is not a case study, but very interesting, written by a judge themselves. Very interesting when we're talking here about judicial neutrality and independence, is how neutral and independent can a judiciary be if it is made up of a particular section of society, if it is not socially representative. And this judge here makes the argument actually it can't. And if you look at the sentencing statistics in the UK, this judgment is backed up. You can see disproportionate sentencing for particular communities, particularly working class communities and communities of colour in the UK. So is the judiciary really neutral? Is it applying the law blindly? It seems to not be. Okay, so those case studies could turn up in any of these boxes. Don't obsess with filling them out, please don't, but they could be useful for you in some of these boxes as examples of the points you're trying to make. For instance, the one I just mentioned could go in here around the backgrounds of many of the judges. Okay, and then in the plenary, I'd really be interested to hear your thoughts about the judiciary. Is it neutral? Is it independent? And what are its strengths? What are its weaknesses? You could get an essay, evaluate the extent to which the UK's judiciary is neutral and independent. It would be quite a narrow essay, but you could get it. So think about matching up those points in the previous, in the page in the note taker about, the representativeness of the judiciary, maybe the political independence of them and political neutrality. You might want to think about debating those points and how you might write an essay on them. Okay, and that's your revision checklist on the stuff that we have now covered. Give that a shot, see how it goes, and do comment your plenary answers as well as if you've got any questions. Bye.